Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. Yesterday we learned that Venable, the firm representing Taylor Swift, had filed a motion to quash Justin Baldoni and the Wayfarer party's subpoena. In that motion to quash, they confirmed that they received the subpoena on April 28th, which is the day that everyone was blowing up my phone about how Ryan Reynolds had been unfollowed by Travis Kelce. So that was the day they learned that the Wayfarer parties were going to be requesting documents and communications. In a footnote in that motion to quash, it also confirmed that Taylor Swift's subpoena had been served on May 8th. Which is why all that news came out the next day on Friday. We haven't seen a motion to quash the subpoena for Taylor Swift herself. I don't know if we should expect that or not. I feel like there was pretty good reason, personally, to serve her with the subpoena, but we'll have to wait and see. In the meantime, Blake Lively and Ryan Reynolds have filed a motion to intervene and to quash that third-party subpoena against Venable. Here's the letter they wrote to Judge Lyman this morning. Blake Lively and Ryan Reynolds respectfully submit this letter to advise the court of a dispute concerning the Wayfarer party's third-party subpoena to Venable LLP. On April 28th, counsel for the Wayfarer parties served a notice of intent to subpoena Venable, a law firm that does not represent any party to the actions and, as of the date of service, did not represent any third party served with discovery in either of the actions. The subpoena seeks 1. All communications between Venable and the Lively Reynolds parties concerning the actions, 2. All documents concerning such communications, and 3. All communications between specific attorneys concerning Ms. Lively. On May 12th, Venable filed a motion to quash the subpoena in the District of Columbia. In the interest of judicial economy and efficiency, the Lively Reynolds parties joined Venable's motion in full and filed a motion to intervene for the limited purpose of moving to quash the subpoena. The subpoena seeks the Lively Reynolds parties' attorney communications, including those of Michael Gottlieb, with no explanation as to how they could be relevant to any party's claims or defenses in the actions. In light of this, the Lively Reynolds parties have requested that the subpoena be quashed. Here's the actual document for Lively and Reynolds' motion to intervene and quash the subpoena. The Lively parties have a substantial interest in the subject of this action, and the court's disposition of the action may impair or impede the Lively parties' ability to protect their interest. The Lively parties seek to intervene to challenge a subpoena that requests documents, to the extent relevant at all, that may contain the Lively parties' confidential information and their counsel's work product. The court should quash the subpoena or otherwise enter a protective order. Counsel for the Lively parties have conferred with counsel for Venable and for the Wayfarer parties prior to filing. Venable does not oppose the Lively parties' motion to intervene. Counsel for the Wayfarer parties did not respond to a request for their position as to the motion to intervene, and their position remains unknown. In response to the Lively parties' attempts to confer with the Wayfarer parties regarding the subpoena, the Wayfarer parties did not substantively engage, as further discussed in the memorandum of law accompanying this motion, which has led the Lively parties to conclude they are at an impasse and that further attempts to confer would be unsuccessful. A lot of this is just rehashing the claims involved in these cases. They're saying that Wayfarer served the subpoena to Venable, and on the date of service, Venable did not represent any third party served with discovery in either action. But remember, Taylor Swift's subpoena was served well after this subpoena to Venable was served. None of the more than 250 requests for production that the Wayfarer parties have served on the Lively parties in the underlying litigation have asked for this information. Thus, the only conceivable interpretation of the Wayfarer parties' decision to subpoena Venable is that they hope to obtain the communications of their own opposing counsel via a third-party subpoena. In response to attempts to confer relating to the subpoena, the Wayfarer parties implied that they intended to work solely with Venable and not undersigned counsel, and therefore did not need to explain how the subpoena possibly could be relevant to any claims or defenses in the actions, stating only that the purpose of the subpoena is to require production of documents relevant to the case. But the Wayfarer parties must explain to this court why they are seeking opposing counsel's communication from a third-party law firm, including why they are relevant to any claims or defenses, and how any responsive relevant materials would not be protected work product. The court should not condone the Wayfarer parties' abuse of the discovery process. The requested information is here. All communications between Venable, including without limitation, Baldridge, and the Lively parties, including without limitation, their counsel concerning the action. All documents concerning communications between Venable, including without limitation, Baldridge, and the Lively parties, including without limitation, their counsel. All communications between Baldridge and Gottlieb concerning Blake Lively from June 1st, 2024 to the present. Baldridge is a partner at Venable and also the attorney for Taylor Swift. These are emails between Blake Lively's counsel and the Wayfarer party's counsel. Lively's counsel is asking them to explain the information requested in the Venable subpoena and how it's relevant to any of the parties' claims or defenses, and to provide all legal authority that supports subpoenaing a law firm. Jason Sunshine responded, "As a threshold matter, who is we? Miss Lively? If so, a back and forth about relevance would be pointless in light of the well-established principle that a party lacks standing to challenge subpoenas issued to non-parties on the grounds of relevancy or undue burden." Lively's counsel again responded, "The law firm you subpoenaed is not a party to this lawsuit and does not represent any parties or non-parties who have been served with discovery in this action so far as we know. So, as best we can tell, the only purpose of the subpoena is an improper attempt to obtain Miss Lively's attorney's communications with other lawyers without any explanation as to why such information is relevant to any claim or defense in the case. So far as we know, there is no precedent in this district for issuing such a subpoena. As a party, we are entitled to know the purpose of subpoenas you propose to serve, including third-party subpoenas, hence our questions. As you surely know, under the federal rules, third-party subpoenas must be limited to non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. We understand your statement that we intend to work directly with Venable and its counsel to mean that you do not intend to confer with us, notwithstanding our attempt to do so. If that is not the case, let us know by close of business today or we will proceed accordingly. And then finally, the Wayfarer counsel responds, the purpose of the subpoena is to require production of documents relevant to this case. We are always willing to meet and confer with opposing counsel, but it does not appear to us that your clients have standing to object to the subpoena, which is not directed to them. If there is a basis for believing otherwise, please provide it. We'll get a little more into the rest of the document, what exactly they're asking and why with Omar tonight, but that's all I got for right now. So thanks for watching. I'll see you all soon.